Hello again, and I'm Dr. Chris Rapoff of Easy QME Continuing Education, and welcome to this presentation. I'm convinced you're going to find this information invaluable as we get into the mindset of a currently presiding California workers' compensation judge, and we get their opinion as to what they feel constitutes a good QME report. Let me preface this discussion by giving you a little background. I recently reached out to several current California workers' compensation judges in an effort to get their perspective on what they can constitute as a good QME report. The first one I've heard from is the information you're going to be receiving today. And as we move along, I will be presenting other information and from other judges as well. But first of all, I wanted to let you know that the opinions are from an experienced, well-respected workers' compensation judge in the Bay Area. And these opinions, they wanted me to make specifically clear, were the opinions are solely those of the judges and not the opinions of the Division of Workers' Compensation of California. Now let's get to it. And to start off our conversation, I asked the judge, in their opinion, what was the utmost important aspect of a QME report. And they indicated that providing a permanent disability rating or an impairment rating, as we do, has to be accurate and it has to be rateable. It must absolutely be reproducible as well. Reproducibility, the definition, as I state here, is the ability of an independent investigator to draw the same conclusions by following the documentation shared by the original investigators. The reason why I put that is if you see documentation is important here. In a QME report, it doesn't suffice to just leave your impairment rating and not explained. That's why you're supposed to provide the tables, table number, figure number, page numbers, and of utmost importance as well, if you can use quotes from the AMA guides, you are just substantiating your medical opinion here. And the judge also made a point to talk about the DEU rater. And what they actually do is they take our reports apart. And this is what they do 40 hours a week. So what they're doing, they are actually checking for calculations and checking to see if the calculations are accurate. They also will take a look at the measurements and see if the measurements and the conclusions actually make sense. Also, are they able to follow the doctor's reasoning? If you're getting from point A to point B, you have to provide the steps for them to follow so they can see that you know what you're talking about. And they also mention that it's really not necessary to wrap your impairment rating in a bow, meaning providing the impairments, say for instance, for lower extremity, upper extremity, spine, and then you create a final whole person impairment rating. The whole person impairment rating isn't nearly as important as the separate sections of your impairment rating, so there's no need to wrap it all up in one conclusion. Also, do the opinions and the conclusions qualify as substantial medical evidence? If you've listened to any of the presentations that I've provided in the past, you'll find that I've been harping on this for the past year, that we do have to have our reports qualify as substantial medical evidence. And with that, they ask, did the doctor provide the how and the why? How I came up with the conclusion and why I did. And if you recall, reasons for my conclusion include and bullet points, and then you give your answers that way. Very appropriate. The judge also made a very interesting declaration to me, talking about ALMARAZ-GUZMAN, the ALMARAZ-GUZMAN analogy. They stated that don't be fearful to use that. That's what was provided for in the decision, the ALMARAZ-GUZMAN decision. But also they stated that if the QME uses an ALMARAZ-GUZMAN analogy rating in the report, and the quote was directly from the judge, the doctor means what they're saying and they know their stuff. So in this case, the judge actually encourages the parties to settle the case, provided the impairment rating calculations are correct. So using an ALMARAZ-GUZMAN analogy, at least in this judge's opinion, says that you know what you're talking about, and they give more credence to your report as a result. Now, with the ALMARAZ-GUZMAN analogy, there must be steps that are utilized, and they have to appear in your report. So there are 4 steps for a proper ALMARAZ-GUZMAN argument, and we'll discuss those here. So as part of your ALMARAZ-GUZMAN analogy argument, it has to have 4 different components to the argument. And you need to specify this in your report. So number 1, you provide a strict impairment rating. And you, under this heading, you tell them exactly how you arrived at your conclusions and why. And number 2, you then state why the strict impairment rating is not accurate. You tell them how you feel that this would not be appropriate, and you have another idea. Number 3, you provide an alternate impairment rating, and this is what your AG argument would be. So you provide an impairment rating that is not part of the strict application of the guides. And then finally, number 4, alternate impairment rating is the most accurate. Now, you did tell them what your alternate impairment rating was in your 3rd section here, but in the 4th one, you then have to tell them why you feel it is more important and more accurate than the strict impairment rating provided in the 1st section of your analogy. Let's talk about some other issues with regards to a report. Many times when a case comes to trial, the QME's report isn't the issue, or the content of the report isn't the issue, but it's an administrative or a legal issue that they're arguing over. One major factor that brings a case to the judge is the QME's lack of compliance with a requirement. Most commonly, if you fail to meet the timeline requirement. One of the parties will use that against the QME like, as the judge said, a dog with a bone and they won't let it go. So in that case, the judge must follow the law. Another one would be ex parte communication. In review, ex parte is a Latin phrase meaning on one side only, or by or for one party. So ex parte communication occurs when a party to a case or someone involved with a party talks or writes to or otherwise communicates directly with the judge or one of the attorneys or the claims administrator about the issues in the case without the other party's knowledge. It's definitely a no-no, but it does happen. Third, did the doctor answer the questions posed in the cover letters? We strongly urge QME doctors to read those cover letters and comply with the questions and answer each and every one. The 4th one is a surprising one for me. Another issue that they did mention very commonly is for getting kicked off of a panel is when the QME doesn't schedule a deposition within the 120-day period. Now, this may be changing a little bit and may not be as big of an issue as it used to be, because it used to be 90 days you would have to schedule the deposition, but now the law has changed, so we get 120 days. But for many, the aspect of the QME process sitting for a dreaded deposition is really, really a problem. So some QMEs just don't respond to the attorney's request, maybe in hopes that if they don't respond, the issue will just go away. And it's true, it will go away when the attorney petitions for another panel. Then your efforts and the cost of the report is then wasted, as they must now start the process all over again, and not to mention how the delay can affect the applicant's ability to get the medical care that they're entitled to. Another aspect that the judge mentioned absolutely floored me. I had no idea that this was actually viable. But they indicated that the doctor's reputation as a QME has a lot to say and a lot to do with your report. And what I mean is in panel disputes, the judge has the discretion to, as they said, fashion a remedy. And this judge's approach is that they tell the attorneys, let's look at the QME database, not worry about the doctor's specialty, but let's find a QME that produces a good report, and that's all that matters. And obviously, the doctor's reputation is key here. So producing quality QME reports does enhance your reputation among the attorneys and the judges, so they will seek you out. Also, the attorneys have a list of go-to doctors to use and a list of no-nos that they will use, and it's their right to strike them from the 3 QMEs randomly chosen for the panel. So keep this in mind in your future reports. It is very important to provide a good report to get, establish, and retain your reputation. And one final thought that the judge wanted to impress upon me is overall, the doctors are doing a good job. They are very responsive to the questions, requests for supplementals and reevaluation. So it's very encouraging to hear. It's just that we do know that there's always room for growth and there's always room for improvement. But you basically, if you see, they even mentioned that the QME potentially represents a lot of money to the parties, and our findings are really relied upon to produce and provide an accurate outcome for everybody. So keep that in mind. Well, doctors, there you have it. I hope you enjoyed this presentation as we heard from the other side, so to speak. My conversation with this judge was something of a report card for the QMEs and for our reports, and it sounds like overall we're doing a pretty good, decent job, but there's always room for improvement, and we also need to be aware of some of the common pitfalls to avoid, and as I discussed some of the most common ones in this presentation. So in the future, we'll be interviewing more workers' compensation judges, and I again will share this insights with you for the QME process to help us all become better QMEs. I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation, the QME report from a workers' compensation judge's perspective. Thank you.